Hi, I'm Simone Green. I'm a family lawyer and accredited specialist with Russell Kennedy Lawyers. I'd like to talk to you today about the Family Law Amendment Act and the big changes coming to the family law system commencing on the 6th of May 2024. Following an inquiry into the family law system by the Australian Law Reform Commission, Parliament adopted some of the key recommendations with an aim to simplify the Family Law Act and make it more user-friendly for those within the system. In this video, I'll give you a brief overview of the changes and how they will impact child-related proceedings after the 6th of May 2024, with further information in the following videos. So, what's changing? Well, firstly, the simplification of how a court determines what's in a child's best interest. The factors that the court considers are reduced from 2 primary considerations and 14 additional considerations to 6 non-hierarchical general factors. Secondly, the removal of the presumption of equal shared parental responsibility. This is one of the most controversial amendments. There is now no longer any requirement for the court to consider making an equal time order when they deem it in the best interest of a child. Also is the removal of the term substantial and significant time. The court can still make any order it chooses in the best interest of a child, however. Guidance on joint decision making. The amendments include a new provision that parents are required to consult each other about major long-term decisions regarding their children, provided it's safe to do so. This is not a binding directive, it's merely guidance on what the court expects when there's no specific order on the issue. Where an order does provide for joint decision making about a child, there is a requirement for the parents to consult before making that decision, but also to make a genuine effort to come to a joint decision. Anything that's not a major long-term issue regarding a child doesn't require consultation between the parents. For example, the food the child will eat, the activities the child will do when they're in the care of either of the parent. That's not a long-term decision and doesn't require consultation. Harmful proceedings orders. Sometimes in family law proceedings, one of the parties might file repeated applications about trivial issues, which has the flow-on effect of the other party suffering from distress in having to meet continual responses to those applications. This can cause financial stress and emotional stress to the other party and to any child. So what's the court doing about this? Well, under the amendments, the court can now step in and restrain that party from making any further applications of that kind without permission from the court. Communication of details about family law proceedings to the public. Communication of details of family law proceedings has always been prohibited. What's changed? It's simplified and clarified as to what it means to communicate details to the public. The amendment clarifies that parties to family law proceedings may make private communications about those proceedings to their family or friends, for instance. What is problematic, however, is when any details of family law matters are posted publicly, for instance on social media platforms, even when the party isn't specifically identified. Extreme caution should be used before posting anything to social media. So, the key points to remember: the changes are coming on the 6th of May 2024. The changes apply to all new and existing cases after that date. It simplifies and clarifies the Family Law Act. If you have any questions regarding the above, don't hesitate to contact the experts at Russell Kennedy Lawyers. I've been Simone Green and I'm here to help you with any of your inquiries. Thank you so much for watching.